Welcome to all of you, Shiksha 360. And today, basically, we have to discuss the LRB chapter number 53, that is the dissolution of a firm. Clear? So, basically, we have already discussed regarding the partnership firm. Now, in this session, basically, first of all, basically, we have discussed regarding the dissolution of a firm. And after that, basically, we have to discuss what is the effect of non-registration. Clear? What is the effect of non-registration of a firm? Clear? What is the effect of non-registration of firm? So let's start our discussion one by one. So dissolution of a firm. Clear? So how can firm be dissolved? And what are the reasons? Basically, we can say that basically with the help of that, basically we can stop the dissolution of a firm. Clear? So a partnership firm, clear, a partnership firm can be dissolved. This means that the partners can decide, clear, a partnership firm can be dissolved. Basically, this means that the partners can decide to stop carrying on the business for which it is formed, and the partners can decide their share. Clear? This means that the partners can decide to stop carrying on the business basically for which it is formed, and the partners can also decide their share in the profit or losses as on the date of dissolution, basically after payment of debts and liabilities. Clear? So basically, this means that the partners, clear, it depends upon the partner. That is, we have already discussed that the partnership at will. Clear, basically where they will decide. Clear, this means that the partners can decide to stop carrying on the business basically for which it is to be formed, and the partners can decide their shares. Clear, and the partners can decide their shares in the profit or losses. Clear, and the partners basically can decide their share basically in the profit or losses as on the date of dissolution. Clear, basically how they can move towards their profit and losses basically after all the payment of the debts and liabilities. Clear, basically after the payment of the debts and liabilities. Clear? So dissolution by agreement. Clear? So this is a general discussion. Now basically they can dissolved by an agreement. Clear? If they have done any specific agreement. Clear? That is up to till that basically we are worked in the firm, and later on basically the firm can be dissolved. Clear? So a firm can be dissolved basically with the consent of all the partners. Clear? A firm can be dissolved basically with the consent of all the partners or in accordance basically with the contract between the partners. Clear? So a firm can be dissolved basically with the consent of all the partners or in accordance basically with the contract between the partners. Clear? Or in accordance basically between a contract with the partners. Clear? So in this way basically the firm can be dissolved. Further, compulsory dissolution. Clear? So at some time basically there is a compulsory dissolution. Clear? That is the firm now can be dissolved. Clear? That is, it must be dissolved. Clear? So what are the reasons behind that? Clear? So a firm is dissolved. First one is if all the partners, clear, a firm is dissolved basically if all the partners except one. Clear? If all the partners basically except one are adjudicated insolvent. Clear? Basically are adjudicated insolvent. Clear? Basically like through a basically decision of a court matter. Clear? That is insolvent. Clear? That is basically they are not able to pay the money. Clear? If all the partners basically except one are adjudicated insolvent. Clear? Second one is by the happening of an event. Clear? By the happening of an event basically which makes it unlawful for the business itself. Clear? By the happening of any event basically which makes it unlawful for the business itself to be carried on. Clear? Basically by the happening of any event basically which makes it unlawful for the business itself basically to be carried on, or the event makes the business unlawful. Clear? Or any specific event basically makes the business unlawful if it is carried on in a partnership. Clear? Clear? So now let's discuss basically by the happening of any specific event basically which makes it unlawful for the business itself to be carried on. Clear? Or second one, that is basically or the event makes a business unlawful basically if it is carried on a partnership. Clear? That is basically there is any unlawful activities to be going on. Clear? There is any unlawful activity basically it is going on, that is the reason basically for the dissolution. Clear? Next one is, however, if the partnership firm is carrying on more than one separate business. Clear? Like sometimes basically there are sometimes basically this thing is also happening that the partnership firm basically they are doing more than one business. Clear? Basically they are doing more than one business. Clear? Is carrying on basically more than one separate business. Then the illegibility of one or more basically does not cause the dissolution of the firm. Clear? So basically, like we can say that basically they are doing this business, they are doing this business, they are doing this business. Clear? So it depends. Clear? Like if they are doing any unlawful business that is separate. Clear? So it will not impact to the other. Clear? Basically, the illegality of one or more basically does not cause the dissolution of the firm. Clear? The illegality of one or more basically does not cause the dissolution of the firm. Clear? So the firm can continue to carry on its lawful adventures and undertakings. Clear? The firm can continue to carry basically on its lawful adventures and undertakings. Clear? On its lawful adventures and undertakings. Clear? So please remember all these things regarding the compulsory dissolution. Clear? So please remember that is basically adjudicated insolvent in that case, or by basically by the happening of an event basically that makes the business unlawful. Clear? Basically that makes the business unlawful. Clear? Now next one is basically dissolution on the happening of certain contingencies. Clear? Basically dissolution basically on the happening of certain contingencies. Clear? So a firm is dissolved. Clear? Basically a firm is dissolved basically in the following circumstances. Clear? A firm is dissolved basically in the following circumstances. First one is basically in the following. Clear? Basically, but to avoid the dissolution basically in these cases. Clear? To avoid the dissolution basically in these cases, the partner should expressively agree that the firm shall not be dissolved in these circumstances. Clear? So basically what we can do basically in these cases to avoid the dissolution. Clear? So to avoid dissolution basically in these cases, the partner should expressively agree that the firm shall not be dissolved in the following circumstances. Clear? First one is if the partnership is constituted basically for a fixed term. Clear? Like basically we can say that basically they are doing the business basically up to this much year. Clear? Or basically up to 5 years. Clear? So during that period, clear, if there is any happening, so basically they will try to continue the firm. Clear? So basically if the partnership is constituted basically for a fixed term, so then by the expiry of that term. Clear? So then by the expiry of that term. Clear? So basically they have to expressively agree. Clear? Basically they have to do agree basically the starting. Clear? Basically if anything happening, so basically they will even continue that basically up to that. Clear? So if the partnership is constituted basically for a fixed term, then by the expiry of that term, clear, they will continue the firm. Second one is if the partnership is constituted basically to carry out one or more adventures or undertaking, then by the completion thereof. Clear? Like we can see that basically we have to complete this project. Clear? Till the completion of this project, basically we are working in the form of the firm. Clear? So that is the same thing they are saying, that basically if the partnership is constituted to carry out one or more adventures, clear, or undertaking, clear, then by the completion thereof, clear, they have to work on that. Clear? Next one is third one. This is basically by the death of a partner. Clear? Basically by the death of a partner. Clear? During that, if there is any partner expired, clear, during that period, clear, even they will continue the firm. Clear? Even they will continue the firm. Clear? Rest, what are the terms and condition behind that? That is a different thing, but they will continue that. Clear? But they will continue on that. Clear? Or by the execution of a partner as an insolvent. Clear? Basically by the execution of a partner as an insolvent. Clear? Even in that case, basically they will continue. Clear? Even in that case, basically they will continue the firm. Clear? So execute, basically I have already tell you basically that is make a formal judgment. Clear? That is basically judgment is to be made. Clear? Against any partner. Clear? Like in a disputed matter. Clear? Or anything. Clear? By the execution of a partner, like we can say that basically any of the partner basically declared as an insolvent. Clear? Even in that case, basically they will continue the partnership. Clear? Basically they will continue the partnership. That is the firm cannot be dissolved even in that case. Now this one, first of all, basically I will discuss, that is dissolution by an agreement. Second one, compulsory dissolution. Third one is basically dissolution on the happening of certain contingencies. Clear? Even we can control in that. Next one here, that is the dissolution by the court. Clear? That is firm can be dissolved by the court. Clear? Firm can be dissolved by the court. Clear? So now let's discuss regarding that. So at the suit of the partner, the court may dissolve a firm basically on any of the following grounds. Clear? Basically at the suit of a partner, the court may dissolve a firm on any of the following grounds. Clear? First one is that a partner has become of unsound mind. That is basically we can say that not mentally stable. Clear? That is not mentally stable. Clear? In simple language, we can say that a partner has become of unsound mind. Second one is that a partner other than the partner. Clear? Next one is basically that a partner I think there is some error here. Where basically that a partner other than the partner suing for dissolution. Clear, suing for dissolution has permanently incapable of performing his duties. Clear, basically has permanently disabled basically for performing his duties. Clear, as a partner. Clear in that case. Clear. That is basically it means that appeal formally to a person for something. Clear, appeal formally to a person for something. Clear, that is basically they can say that basically he is not capable to do the business. Clear. So they want that basically firm can be dissolved. Clear, that a partner other than a partner basically suing for decision has become permanently incapable of performing his duties basically as a partner. Clear. For third one is basically that a partner is guilty of conduct basically which is likely to affect prejudicially the carrying on of the business. Clear, like basically they are doing something basically which will impact their, or we can say that basically the image of the business, basically image of the partnership firm is going to be down. Clear. So basically in that case. Clear. Fourth one is basically that a partner willfully or persistently commits breach, basically not following the laws or rules and regulations, willfully or persistently, that is regularly commits breach of agreements. Clear, basically in relation to the management. Clear, in a relation to the management of the affairs of the firm or conduct or the conduct of its business. Clear, or the conduct of its business, or it is not reasonably practicable. Clear, or it is not reasonably practicable basically for the other parties to carry on the business in partnership with him. Clear, to carry on the business in partnership with him because of his conduct basically with respect to the business. Clear, because of his conduct basically with respect to the business. Clear, that a partner basically willfully or persistently commits breach of agreements in relation to the management of the affairs of the firm or the conduct of its business, or it is not reasonably practicable basically for the other parties basically to carry on the business in partnership with him because of his conduct basically with respect to the business. Clear. Next one is basically that a partner has transferred the whole of his interest basically in the firm to a third party. Clear, basically in that case also, that is basically when they have transferred basically, or is that is basically they can do business basically on their behalf. Clear, on their behalf, that is basically to a third party. Clear, in that case also basically dissolution of the firm is to be done. Clear, dissolution of the firm is to be done. Clear. Next one is that the business of the firm basically cannot be carried on except at a loss. Clear, that the business of the firm basically cannot be carried on except at a loss. Clear, that is. Next one is basically on any other ground. Clear, basically which renders it just and equitable that the firm should be dissolved. Clear, like we can say that basically in simple language that the work is not going properly. Clear, work is not going properly. Clear. So in that case also basically we will prefer that the dissolution of the firm. Clear, dissolution of the firm. Clear, or basically we will go with the decision of the court. Clear, that is basically there is a problem going on. So basically we will come here basically for the decision. Clear, that is basically we want to dissolve the firm. Clear. So these are the things. Clear. And in the examination was just what they will do. They will give 3 to 4 points like 1, 2, 3, 4. Like A option 1 and 2 is correct. B option 1 and 3rd is correct. C option that is 2, 3, 4 is correct. The option is none of the above. Clear. So in this way, basically they will provide you the options. Clear. Basically they will provide you the option. So that's basically you have to answer the question according to that. Clear. So you have to answer the question basically according to that. Clear. So please remember all these things. Clear. Please remember all these things while solving the questions. Clear. While solving the questions. Clear. That is basically dissolution on the happening of certain contingencies, basically dissolution by the court. Clear. Dissolution by the court. Clear. Now next one is basically liability for acts of partners done after dissolution. Clear. What is the liabilities, or basically how the partners basically will treat basically after the dissolution. Clear. Basically after the dissolution of the firm. So basically any partner of the firm. Clear. Basically any partner of the firm must give a public notice to the effect that the firm is dissolved. Clear. Basically any partner of the firm basically must give a public notice to the effect, like basically we can say that basically publication in the newspaper. Clear. That is any partner of the firm basically must give a public notice to the effect that the firm is dissolved. Clear. Basically that the firm is dissolved. Clear. This is because even after the dissolution of the firm. Clear. This is because even after the dissolution of the firm, the partners continue to be liable to third parties basically for any act done by any of them until such public notice is given. Clear? If they are not given, like basically we can say that basically there are three partners, P1, P2, P3. P1 and P2 are working properly and basically they are genuine person. Clear? Basically, but P3, it always basically insists on doing the frauds. Clear? Basically, it always insists on doing the frauds. Clear? So now, in that case, clear? So basically now in that case, basically what will happen, that is, if firm is to be resolved, clear? Basically firm is to be resolved, clear? So basically they have to give a public notice, clear? Basically they have to give a public notice, that is basically the firm can be resolved, clear? Because if they will not doing anything regarding that, clear? So basically if there is any work is to be done by this one, clear? They even not giving the public notice, clear? So all the partners are liable for that, clear? So all the partners are liable basically for that, clear? That's why they are saying that basically they have to give the public notice, clear? That is, they have to give the public notice regarding that. Okay, so please remember all these things, clear? So please remember all these things while answering the question, clear? That is liability of forex of partners basically done after dissolution, clear? So basically this is overall regarding the dissolution of a firm, clear? This is overall discussion regarding the dissolution of a firm. Now next one, that is basically chapter number 54, that is effect of the non-registration, clear? Very short chapter, clear? All these chapters are basically just one or two pages chapter. So basically we have to cover all these things, clear? So basically we have to cover all these things, clear? Effect of non-registration, clear? Effect of non-registration. So a company is compulsorily required, clear? Basically a company is compulsorily required to be incorporated and registered, clear? Basically a company is compulsorily required to basically to be incorporated and registered basically with the registrar of companies, clear? A company is basically, sorry, yes, a company is compulsory required basically to be incorporated or registered with the registrar of companies, clear? Under the Companies Act 1956, clear? Basically if you are forming any company, so basically they have to be compulsory required to be registered basically under the Companies Act 1956, clear? On the other hand, basically there is not any compulsion regarding the partnership firm, clear? However, a partnership firm basically is not required to be compulsory registered basically with the registrar of partnership firms, clear? However, a partnership firm basically it is not required to be compulsory registered, clear? Basically to be compulsory registered basically with the registrar of partnership firms, clear? Basically with the registrar of partnership firms, clear? So please remember that, clear? Company is required to be registered, clear? With the Companies Act 1956. On the other hand, partnership firm, it is not required to be registered, clear? Basically with the registrar of partnership, with the registrar, clear? That is basically there is not any requirement, clear? So what is the impact, clear? And in some states basically you will find it, clear? Basically there is a rule regarding the registration of the firm, clear? Which we have to discuss, clear, in the upcoming sessions, clear? Now next let's discuss, that is registration, clear? So the partners may or may not enter into a partnership deed, clear? The partners basically may or may not enter into a partnership deed and may decide to have an oral partnership, clear? Basically the partners may or may not enter into a partnership deed and may decide to have an oral partnership if they have a strong outstanding, clear? Basically and may decide to have an oral partnership basically if they have a strong outstanding amongst themselves, clear? Basically strong understanding amongst themselves, clear? So it depends upon them, clear? Basically whether they want to register or not, clear? It depends and may, like basically we can say that orally they think that basically they will become a partners, clear? Just we can say that like two friends and they're very close friends, clear, and good friends, clear? So just they are not doing any agreement, just they are continuing any business, clear? That is 50-50 share because they are giving 50-50 amount in the company or basically in the partnership firm basically to carry on the business, clear? Further, even if a partnership deed is entered into by the partners, so they may not opt for the registration of the partnership firm, clear? Even basically we can say that basically there is a partnership deed, clear? Partnership deed is must, clear? Basically for the partnership firm, clear? Like basically you are going to the bank, clear? Basically for opening the account, clear? Basically for opening the account of the partnership firm, clear? So at that time also basically partnership deed is present, must, clear? Partnership deed is must, clear? Further, if a partnership deed is entered into by the partners, so they may not opt for registration of the partnership firm, clear? However, the Partnership Act basically casts certain disabilities basically on a partnership firm. that is not registered with the register of partnership firms. Clear? So due to this provision, clear, which is stated basically in the section 69, a majority of the partnership firm decide to register the firm basically to avoid future hassles and complexities on solving issues basically amongst the partners as well as the third parties. Clear? So basically there are some rules and regulations. Clear? We know that basically why the acts are to be formed. Clear? Acts are to be formed basically to make the work easier. Clear? Basically to make the work easier. Clear? So now basically they will try to formulate basically certain rules and regulation under the partnership act. Clear? So that basically the partners or the firm that is basically will not face any problems. Clear? As the work is going on. Clear? So what are the provisions? Clear? Basically that they have to mention in the section 69. Clear? So the provision of the section 69 are briefly stated here under. Clear? So now let's discuss what are the benefits basically of registering the firm. So if partner of an unregistered firm, clear, a partner of an unregistered firm basically cannot enforce by way of a suit any right available to him under the Partnership Act or a right conferred by a contract amongst the partners against the partnership firm or any partner thereof. Clear? Like basically we can say that basically if they want to basically utilize any right, clear, like basically they want to file any suit, clear, or basically by the way of any suit, basically we can say basically by the way of any legal action, clear, they will not do that work. Clear? Because they will do not do that work because that rules and regulation basically that is only applicable for under the part that are basically applicable basically on those partnership forms or basically on those forms which are registered basically with the Partnership Act. Clear? Basically which are registered with the Partnership Act. Clear? So a partner of an unregistered firm basically cannot enforce by way of a suit any right available to him under the Partnership Act or a right conferred by a contract amongst the partners. Clear? Or a right basically conferred by a contract amongst the partners against the partnership firm or any partner thereof. Clear? Against the partnership firm or any partner thereof. Clear? Similarly, an unregistered firm, clear, similarly basically an unregistered firm cannot enforce by a way of suit any right arising by a contract basically against any third party. Clear? Arising by a contract basically against any third party. Clear? Like basically we can say basically they are doing work basically with the other parties. Clear? So even at that time basically if they are facing an issue, clear, so basically they will not do any legal action. Clear? Basically they will not do any legal action. Clear? However, the enforcement of any right to sue for matters relating to the dissolution of firm is not affected. Clear? Basically but even if the firm is not registered, clear, and basically for the matter regarding the dissolution of the firm, there is not necessarily that it has to be registered. Clear? However, the enforcement of any right basically to sue for matters relating to the dissolution of a firm is not affected and can be brought before the court of the law. Clear? Basically it is not affected and can be brought basically before the court of the law. Clear? And that can be brought basically before the court of the law. Clear? So these are the some terms and conditions basically which they have mentioned under the Partnership Act. Clear? Under the Partnership Act, and we have already discussed basically what are the impacts of the registration of the partnership firm. Clear? So hope it is clear to all of you regarding the partnership firm. Clear? Basically we have discussed from chapter 49, 50, 51, 52, 53, 54. Clear? So all these 6 chapters are related to the partnership firm. Clear? Even till chapter 52 basically we have covered the MCQ also. Clear? Basically we have covered the MCQ also. Today basically we will discuss the theory also. So basically after the completion of next 2 chapters, clear, 55, 56, clear, that is basically related to the Companies Act. After that, clear, basically we will discuss the MCQ. Clear? After that basically we will discuss the MCQ, and definitely you will get basically 3 to 4 questions basically directly in the examination basically from these 4 chapters. Clear? Even more than that. Clear? So overall basically from these 6 chapters, clear, we will expect 7 to 8 questions. Clear? Basically we will expect 7 to 8 questions. Clear? Like some question of 0.5 marks and some question of 1 mark. Clear? Not 2 marks question basically we will expect from that, because that are not that much technical based things. Clear? That are not basically that much technical based questions here. Clear? So in the next session basically we have to discuss start our next chapter, that is chapter number 55, that is definition and features of a company. Clear? Definition and features of a company. Clear? So basically we have to start our discussion in the next session on that. Clear? Very, very important. All these chapters are very, very important, and directly basically you will get straightforward questions. Clear? So thanks to all of you basically for attending this session, and I request to all of you, please go through this session basically at least 2 times so that you are able to understand all the parts. So thanks to all of you for attending this session.